We go to Title 12, Crimes Against the Civil Status of a Person. Under Article 347, the law punishes 3 acts. We have simulation of birth, substitution of one child with another child, and the last one is abandonment or concealment of a legitimate child with intent to cause a said child to lose its real civil status. Simulation of birth is committed when a woman pretends to be pregnant, although she is not, and took the child of another woman. If the said simulation is done in the birth certificate, the crime committed is violation of Article 347. But if the simulation is done in any other document, school records, baptismal certificate, the crime committed is falsification. When you say substitution of one child with another woman, with another child, 2 parents, 2 mothers gave birth in the same hospital. Here comes the accused. The accused exchange both babies. Both babies now acquire a different civil status, both of them having no rights. Substitution of one child with another child, that is the crime committed by the said man. X and Y are husband and wife. They belong to a prominent family, a known family in society. After their marriage, the woman doesn't want yet to get pregnant. And so, she had been taking pills. But she became pregnant. Still, she continued with the pills, hoping that the fetus inside would die, but the fetus survived. And she gave birth to the child, but the moment she gave birth, the husband could not accept the child. The child was born with no legs and no arms. This is a disgrace to their prominent family. Cannot be accepted in society. So both X and Y wrapped the child and placed the child in a basket and left the basket in front of the church, ringing the doorbell. What crime, if any, is committed by these parents who abandoned their legitimate child? It is a violation of Article 347. It is a violation of Article 347. Their intention is to cause said child to lose its real civil status as their child, as one coming from their family. Therefore, the crime committed is abandonment of a legitimate child. Under Article 348, the law punishes usurpation of civil status. Usurpation of civil status is committed by any person who shall usurp the civil affiliation of another person with the intent to enjoy the civil rights arising from the status of the person that he impersonates. If his intention is to defraud the offended party or his heirs, the penalty is qualified. Under Article 349, the law punishes bigamy. Bigamy is committed when a married person contracts a second or subsequent marriage before the first marriage has been legally dissolved. Or when a married person contracts a second or subsequent marriage before the absent spouse had been declared presumptively dead in a judicial proceeding. A married person, before contracting a second marriage, must first legally dissolve the said first marriage. When the law used the word legally dissolved, therefore, there must first be a judicial declaration of nullity of marriage. Hence, he must file a petition for declaration of nullity of the first marriage before she would be able to contract a second marriage. Without the legal dissolution, without the declaration of nullity of the first marriage, contracting a second marriage will make him liable under Article 349. Likewise, a married spouse cannot just enter into a second marriage even if the husband or the wife is absent. He must first file a petition for the presumptive death of the said absent spouse. And if the court declares the said presumptive death, that is the time that he can contract a second marriage without being held liable for the crime of bigamy. X and Y got married. At the time they got married, they are both 16 years old. Therefore, both X and Y lack the legal capacity to enter into marriage. X knew it was a void one. And so, when he found another woman, he married that woman. Anyway, the first marriage was null and void. When the said first wife learned of this, the first wife filed a case of bigamy against the man, against X. The following are the arguments of X. First, according to X, bigamy is not liable insofar as is concerned. He is not liable of bigamy because according to him, the first marriage is a void one and therefore obviously inexistent marriage. Second, according to him, the case of bigamy will not prosper because the first wife filed the case only against him without including the second wife. Hence, it will not prosper. Are his arguments meritorious? Both his arguments have no merits. Insofar as the first argument is concerned, even if the marriage between X and Y, they being only 16 years old at the time, was in reality null and void, Supreme Court said, the law does not give the parties the right to determine whether the marriage is null and void. The first marriage must be legally dissolved. There must be a declaration of nullity. Second, the case will prosper. Bigamy is a public crime. It is not a private crime. The law does not require that both the said man and the second wife be charged in court. He is the only one who committed bigamy because he is the only one who entered into a second marriage. That was the first marriage of the second wife. Therefore, he is the only one liable for bigamy. In a case, however, the Supreme Court said that when the said second wife knew all along that this man whom she married is a married man, the wife is liable as an accomplice in the crime of bigamy. X and Y wanted to get married. X and Y went to a priest. The priest refused to marry them. They went to the mayor of their place. The mayor refused to marry them. They went to the judge within the jurisdiction of their place. The judge refused to marry them. And so they looked for someone who has the authority to solemnize marriage. And they found this minister of a particular religious denomination. He is authorized to solemnize marriage. X and Y went to them. And the said minister solemnized said marriage. X and Y are both male. What are the criminal liabilities of X and Y and the solemnizing officer? X and Y are liable for illegal marriage under Article 350, whereas the solemnizing officer is liable under Article 352. X and Y are liable for illegal marriage because they both knew that they lacked the requisites, essential and formal requisites for a valid marriage, yet they proceeded with a said marriage. They contracted with a said marriage. Therefore, they're liable for under Article 350. Insofar as the solemnizing officer is concerned, although he has the power to solemnize marriage, since he solemnized or authorized the performance of this wedding ceremony, unlawful wedding ceremony, he becomes liable under Article 352. Note, under Article 352, the crime can be committed only by a priest, a minister, or any representative of any religious denomination who has the power to solemnize marriage. If he does not have the power to solemnize marriage, the crime committed is usurpation. But here, he has the power, he has the authority to solemnize marriage, but he performed or authorized the performance of an illegal, unlawful marriage, wedding ceremony. becomes liable under Article 353